sorry. So if you hear barking, that's that's him.
That's
Hey.
participation. Okay, great.
Yeah, making good points. Yeah.
Are you listening to me? Hello?
Yeah, hello.
Oh, hello,
Hi,
good morning, good
yes.
afternoon. This is Johanna here. I'm from Women in Antitrust, and I wanted to know if we are ready to go on YouTube.
Yes, please, let's go.
Yes,
So
we are. Yes, we are.
Yeah, I will make a quick introduction and then I will go, I will turn off, okay?
Good. All right.
Okay.
Okay, perfect. Just 1 second.
This is very modern.
Yes.
Just the propaganda and then you go.
Right. Leonor, are you introducing them, or should I do it?
Yeah,
I do.
Yeah, I'll just introduce you.
Right. So I'll read your short bios. Is that fine? Yeah. Go. Wonderful.
Giovanna, can we go? Are we? No, not yet. So we are live. Good morning. My name is Leonor Cordovil. I'm very proud of being one of the founders of this wonderful network called Women in Antitrust. 3 years ago, 3 good friends from different sides of antitrust were talking about how to increase women participation and leadership in antitrust in Brazil. These friends, Amanda Ataide, at that time Chief of Cabinet of CADE, Juliana Domingues, Professor of Economic Law of the University of São Paulo, and myself, had the idea of creating a network together, all women practicing or studying antitrust in Brazil. 3 years later, we have a very active group of more than 200 women on our WhatsApp group, 800 followers in our Instagram, and 1,800 following our LinkedIn page. We have already published 2 books of articles, and last year we published a very good study on the representation of women in antitrust in Brazil after a big research made with all law firms and consultancy firms active in our country. Managing our network, we have a team of 10 wonderful women really dedicated to spread our ideas and our initiatives. The pandemic gave us the opportunity to promote webinars with stars that we would normally not have access to if we had to promote only offline conferences. Today is a good example. Rachel and Johanna are stars of antitrust in the United States and Germany, and kindly accepted to speak on our second international webinar, and first in English. I would like to thank Paola Pugliese, who is a brilliant lawyer in Brazil with a wonderful experience in mergers, for accepting to be our moderator today. Paola, please have the floor, and I wish you a very fruitful discussion.
Thank you very much, Leonor. And well, I want to start by thanking you, a good friend and such a brilliant and respected lawyer, for hosting this panel, introducing us, and the organization, of course, the Women in Antitrust, that is offering us the opportunity to speak here. And for so far has been gathering these super lawyers and economists and enforcers. So we're making, you guys are making waves in the market. So thank you very much for that as well. And thank you for putting this international panel together. I'm super honored to be part of this and to discuss this very hot topic. Also, failing firm theory, which is that's very opportune as well. So thank you very much for that. And last but not least, thank you very much for our panelists. We have this wonderful panel here and we're lucky enough to hear from both sides of the Atlantic. So, and by saying this, I will introduce Johanna Kübler. She's a partner at Comeo in Frankfurt, Germany. She advises clients on all aspects of German and European antitrust law with a specific emphasis on German and European merger control. So, and Johanna has been recognized and recommended by all these expert publications, the Handelsblatt, Best Lawyers, Chambers, Legal 500, Who's Who Legal, Expert Guys, Wirtschaftswoche, the Juve Handbook. So thank you very much for being here today, Johanna. It's a great pleasure for us. And then we have Rachel Adcox. She's a partner at Aixin. Rachel also advises clients mainly on cartel and compliance matters before the US and international enforcers. She's been recognized also by Global Competition Review as the litigator of the year. Well, that's very impressive. Chambers USA as an antitrust litigation specialist, and by Who's Who Legal as a future competition leader. And prior to being in private practice, she was a trial attorney at the antitrust division of the US Department of Justice. So very impressive. Also, thank you very much, Rachel, for being here. So I'll start by greeting these ladies. Good morning and good afternoon. Again, thanks for being here. Let's have fun, right? As you know, well, we'll talk about for the next hour about this, the fading firm theory, a subject that has been sort of, let's say, a white unicorn in the sense that everyone likes it, everyone talks about it, but no one has ever seen it, isn't it? So it's no news, of course, that it became a hot topic since the pandemic started. With such a dramatic downturn in the economy, we would expect, of course, companies resorting to the failing firm theory. And somehow, apparently, authorities around the globe have immediately reacted by saying, even before this started, by saying, look, no way, Jose, we're not allowing this. So, and this is why it becomes such a hot topic. So with that, I'll start by with our first question, right? So can you both briefly tell us a bit about the fading firm theory, how it developed in the US, how it developed in Europe, how it has been applied so far? And I would be very much interested, particularly in the recent precedents that we know in the CMA with the Amazon Deliveroo case in Europe, and also the Asian Olympic case. So it would be good to hear from you. Let's start with Rachel then.
Okay,
Please.
thank you very much. Thank you to Paola and Leonor, and also the Women in Antitrust group for hosting this very interesting discussion. As you said, in the United States, the doctrine of failing firm is almost 100 years old, and yet we have very little actual jurisprudence to show for it. So it is a little bit of a unicorn. It is often talked about and not as often used or seen, as you would say. The failing firm defense is essentially a complete defense to a merger that the agencies might otherwise consider anti-competitive or would create concerns. And the reason that it would be allowed to proceed is that there would be no other way to keep those competitive assets in the market. The defense was first recognized in the US in a case called International Shoe by the Supreme Court in 1930. And in that particular case, the Supreme Court allowed a merger to go forward due to the dire financial condition of the target. According to the court, the target company in that case, which was called McElwain, was faced with financial ruin, such that the only alternatives presented were liquidation through a receiver or an outright sale. And in those circumstances, the court considered that selling to a successful competitor would avoid a more disastrous fate of having to sell the company's assets through liquidation. And so it was the court's reasoning in this case that became the basis for the three elements of the failing firm defense in the United States that are used to this day. And these elements, in essentially the same form, are recognized by both US courts and within the Department of Justice and Federal Trade Commission horizontal merger guidelines. So specifically, these three elements amount to the merging parties having the burden to show that the target company can't meet its financial obligations in the near future, that it is unable to successfully reorganize under Chapter 11 of the U.S. Bankruptcy Act, so that it can't essentially refinance and emerge in some sort of a more competitive form. And also that the parties have been unsuccessful, despite good faith efforts, in obtaining reasonable alternative offers that would have kept the assets in the relevant market and would have posed a less severe danger to competition. I think it makes sense, with your indulgence, to go into these elements a little more deeply, with a couple of brief case illustrations of how these have been applied in both directions.
Absolutely, yeah.
So if we talk about a firm's inability to maintain its financial obligations in the near future, the specific factors that courts and agencies are considering include that the firm has debts that are due that cannot be covered, that the firm has costs that are greater than its revenues, and also that the firm is unable to obtain loans or raise other capital. There are two cases, I think, that are interesting in different courts, both in 2001, that illustrate different applications of this particular prong of the doctrine. So in California versus Sutter Health Systems, this was a case where the parties actually showed that the firm was effectively already insolvent and that therefore the failing firm defense might apply. In this case, the target was Summit Medical Health Center and showed that it was at risk of imminent financial failure because it was in fact unable to pay its debts. It had significant long-term debt. It was prohibited by its credit agreements from obtaining new credit, and had faced substantial capital expenditures for necessary upgrades to its facilities. Now you can take that case and then contrast it with the case of the Federal Trade Commission versus H.J. Heinz. Here, the court rejected the failing firm defense on the basis that even though the parties had shown that the target's business was stagnant or declining, did not have a realistic prospect of change, and had a highly inefficient plant, the enterprise was still solvent and it was still profitable. It was just increasingly less profitable over time. And in that instance, the target company had not reached the point where the failing firm defense was going to be successful. If you look at the—
Rachel,
go ahead, Paola.
May I stop you there just with one quick question? So in the first case that you mentioned, did the company file for bankruptcy or not? It didn't, right? It just was just insolvent, but not technically bankrupt, correct?
Right. And in fact, that case is also a good example of the second prong of the test, and that they met the element of being unable to successfully reorganize. They hadn't filed.
Okay.
But the court found that they would likely be unsuccessful because it would not produce a solvent reorganized firm. The court found that the more likely outcome was that the assets would be liquidated and removed from the market as a result of a bankruptcy. So good question. To do the flip side of the second prong, there was a case called United States Steel Corp versus the FTC. And the court found that the failing company could reorganize potentially under the bankruptcy proceedings. The target's assets theoretically could have been split into several going concerns and then sold independently in bankruptcy proceedings. And so it ultimately, the court in that case remanded it back to the Federal Trade Commission to reconsider whether or not the failing firm defense would apply in that situation. So the third prong, just briefly, which I think is very interesting, and I assume we'll discuss at some length later, is whether or not there has been another alternate offer for the purchase of the firm. Right, exactly. And there are a number of things that might go to show that good faith efforts had been made to find alternate buyers. These include contacting a number of prospective buyers, including investment firms or companies from related industries, providing sufficient information to companies that express an interest in pursuing the purchase, and then actually pursuing legitimate expressions of interest. And this is something that the agencies do take very seriously. There are a couple of cases, not incredibly recent, but that demonstrate this fact. In United States versus Energy Solutions, that was a case where the court found that the parties had not made good faith efforts to elicit reasonable alternative offers. In that case, the target engaged with only one other potential bidder, who ultimately did not submit a bid. And the target agreed to deal protection devices that made it almost impossible to entertain other offers, such as a no-talk provision that prevented the target from discussing or negotiating any alternative transaction, and a no-shop provision, which meant that the target was prevented from, among other things, soliciting competing bids. So it was almost the polar opposite of doing the shop. It was, you can't do the shop. In FTC versus Harbor Group Investments, the court rejected a failing firm defense where the financial firm searching for an alternative buyer made a minimal effort and over a very short time frame. And then ultimately, if the FTC came forward with prospects for 3 other potential buyers, and the parties rejected all of those buyers. In that case, the court did find that they had not met the element of a good faith search for an alternate buyer. And the timing of looking for that alternate buyer is also important. There has been a case in 2009 where there was a proposed merger of Scott and White Healthcare with King's Daughter. And eventually the FTC determined that King's Daughter was likely to close unless it was acquired by another health system, but did still require the parties to shop the deal. So when the FTC learned that there had been another buyer in the wings and another buyer was interested, but that buyer had no opportunity to participate before the parties had already expressed their intent to merge, the FTC actually did require that the parties entertain that buyer. And it was only when that buyer ultimately decided that it was not interested in making the purchase that the FTC allowed the transaction to close.
Okay. Well, that's very interesting. Thank you very much, Rachel. I think very comprehensive as well in terms of the case law. So I think we will discuss this 3-pronged test quite a bit today. But, without further ado, I'll let Johanna and talk a bit about how this developed in Europe so far.
Yes, thank you. And I'm very honored to be able to speak here. And thanks for WIA for inviting me. It's really a great pleasure. For Europe, I'll speak about the European Union mostly, but also chip in with some national issues, especially in Germany. There's quite a tradition for the failing firm defense. But also Paola also mentioned the Amazon Deliveroo case in the UK. So that's an interesting case as well we should look at. Generally, the background is quite different in the EU, although the 3 criteria we'll see are very similar now. And so in practice, I think I don't need to repeat a lot of what Rachel has said on how to prove that the target the failing firm would be forced out of the market or would be insolvent. That is really very similar. But the conceptual background is quite different. Under the relevant EU merger control rules, a merger can only be prohibited if it leads to a significant impediment to effective competition. So for Germany, for example, the rule example is that if the merger is suspected to create or strengthen a dominant position. So that means that the authority can only prohibit a merger if there is really a causality between the merger and the impediment to competition. On the other hand, if following the merger there is a significant impediment, but the same or a comparable impediment to competition would take place absent the merger, then there is no such causality, meaning that the authority cannot prohibit the transaction. So the background is quite a little different. It's less about saving a firm, saving some of the competition, but it's really initially it was a very formal approach. And that is actually confirmed by the early cases. I mean, our early cases are a lot later than in the US. One of the early ones was in the 1980s in the German market concerning potash, and we'll be dealing with potash a little more today. There was a potash mine that was failing, and there was only one large competitor. And nevertheless, the Bundeskartellamt, the German Federal Cartel Office, the FCO, based on the causality issue, decided that yes, they can merge, because absent the merger, the mine would have been explored by the remaining now monopolist anyway, so they could not prohibit it. They never mentioned the words failing firm. They didn't consider that to be a defense or anything. So it was really a matter of testing along the lines of the German rules and finding, no, we cannot prohibit the merger because the causality between the impediment to competition, at that time it was still the market dominance test, so creation of a market dominance, but that was not given, so they could not prohibit and thus had to allow the merger. Very similar at the EU level, the discussion was finally on the failing firm defense was finally sparked by a case involving potash, you guessed it, and rock salt. It's the case Kali and Salz, K&S, of 1993. That was also focusing on the causality issue. And it was a very, very similar case. Following the German case in the 1980s, we had one monopolist in Germany. Following the German reunification, there was an additional player in the market coming from the eastern side of Germany. So it's very similar situation, very similar arguments that yes, there would a monopoly was at stake in the German market following the transaction, but the same would happen if the merger would not take place. So again, no causality. So the commission said that yes, the target would be the mining company would be forced out of the market if it were not taken over by another company. It had a high level of debt. The insolvency proceedings had not begun, but they were imminent. So that's quite similar to what Rachel mentioned before. And the acquirer, Kali and Salz, K&S, would inevitably acquire the market share of the failing firm in the respective market. And since it was such a special market, there was no alternative buyer evidence. So there was no one else who could have continued the business. So in that case, it was still more of a causality issue, but the failing firm defense was discussed there. There was a previous case where the failing firm defense was discussed, but it was not accepted, and the case was dismissed. Following this K&S transaction, the next case was a lot more important, but quite some time later. In 2001, the commission in the BASF Eurodeal case that's related to solvents, chemical products, the market situation was very different. It was not a duopoly moving on to a monopoly, so a 2-to-1 merger, but there were more competitors still in the market. So here, our formal or very strict causality argument that the market share of the failing firm would accrue to the acquirer did not really work. But since the European Court of Justice had confirmed the K&S judgment of the Commission before, the Commission was a little brave and further developed the failing firm defense by saying that, yes, it is a key requirement that the competitive structure resulting from the concentration deteriorates in a similar fashion, even if the concentration would not proceed. So what they did is they didn't look at the pure causality market share moving from A to B, but they looked at competition deteriorating with the merger or without the merger. So that's quite a broader approach, which was then actually taken over for the horizontal guidelines. So in that case, it was clear that if the target would exit and there was clear danger of the target exiting, its production capacity would be shut down. There would have been production shortage, and that would have led to higher prices. There was growing demand in the market, and there were capacity constraints. So following the merger, it was secured that there's still enough capacity in the market, and that was considered to be less a smaller impediment to competition that it would have been based on the failing firm leaving the market. So the Commission does not require that the acquirer the buyer would inevitably acquire the entire or substantial part of the market share, but it has amended the second prong to saying that the company's assets that are failing, so the failing company's assets would inevitably exit the market if the company was not taken over. So that's quite a little bit broader. For that, it's sufficient if the deterioration of the competitive structure resulting from the transaction will be less significant than it would have been in the absence of the merger. So we see here that we're taking a broader and overall assessment of the economic effects. It's still an issue of causality, of course. The rules didn't change, but they didn't make it as small as it used to be based on market share from failing firm moving to acquirer. So now this is all in the horizontal merger guidelines, and we see that the entire discussion is about the counterfactual. It's all about assessing what the hypothetical changes to the market will be, either in the sense or in the case that the merger does take place, or in the case the merger does not take place. That requires quite a lot of specific indications and a lot of adequate probabilities. That's always an issue. How big must the probability be for the impediment to take place or not to take place? And the counterfactual, and that's sort of the last comment in that context, has played a very important role in a recent case of 2018, the T-Mobile Tele2 case, where the companies developed two variances of the counterfactuals. One was the actual failing firm defense, and the other, a little more optimistic counterfactual, said, well, maybe the target Tele2 will not exit the market, but a lot of high investments would be necessary to remain in the market, and that would lead to increase in prices, incremental costs, increase of prices, etc. That would impede competition. Interestingly, in that case, the Commission did not apply the failing firm defense and said, no, we don't think this is the right probability, but nevertheless cleared the transaction without conditions because they said such a player is not an important competitive force in the future. So it was a counterfactual looking into the future, saying that the competitive force would be lowered and therefore they could clear the transaction. In all of this, the burden of proof is on the merging parties, and that's, of course, an interesting question. How do you prove that there is no less anti-competitive solution or no less competitive buyer? That's always a difficult issue, and I believe we'll be talking about that a little more later on. It is, and that's, I think, quite important to understand, under EU law and very similarly under German law, it's not a justification or a defense. The failing firm defense, we talk about as a defense, but it's not, it's really an aspect of the causality of the significant impediment of competition. But it has only been invoked in a very few cases. So it is still something to go about. Paola, you asked also about the Asian Olympic case and Amazon Deliveroo. That's would go into the sort of the crisis management, and I wonder whether I should stop here and then move on to these cases when we talk about sort of more the.
Sure. Oh, thank you very much, Johanna. I think, yeah, that makes sense. It's good to hear also. It's a very comprehensive, coverage of how this has developed in Europe, and very interesting how different it comes from the US, isn't it? It's good to see. I mean, it's interesting to see how the Brazilian authorities are going, or in what direction they're going with these two different backgrounds. Well, it goes without saying, of course, that we're living in unprecedented times, with companies in certain sectors going through, challenges that were unheard of to name one, let's say the commercial airline industry, right, which is facing a huge downturn, demand coming, as low as zero at some point in time. So one would expect in that scenario to see companies resorting more and more to the failing firm defense. I wonder if you could share with us a bit how the authorities have been reacting to the failing firm theory now during this crisis, and if you see them relaxing the rules a bit or not. The background of this is the following. We have been, there's a very good paper being written by a former commissioner in Brazil, and Marcio Oliveira, and one former head of the economic department studies, Luis Esteves. They're writing and talking about the failing firm theory with a paper that says, very interesting one, saying, look, the three-pronged test, or the causality test in Europe, they were meant for normal times. When normal times mean we have crisis, little crisis, we economy goes up and down, but this was not meant for a black swan like we're living now. So I wanted to hear from you both a bit on how the authorities in Europe and the US are, seeing this. The test was meant for a different time, and how they're approaching this right now. So Rachel, do you want to start?
Sure, thank you. I think the agencies are reluctant to do or project anything right now that would suggest that they would be relaxing the standard. This is quite consistent with past practice, where the agencies historically have not expanded or loosened the requirements of the failing firm defense during economic downturns. I think most recently during the recession of 2008, 2009, and the global financial crisis. The rationale there, I believe, is that just because there's a situation in which the defense may be invoked more often, it doesn't necessarily mean that the ultimate standards of the defense are somehow faulty. And the agencies, however, don't debate that taking into account global and industry-wide financial circumstances is an important element of merger review generally. And that's something that they always take into account when looking at the competitive conditions surrounding a merger. What we might see, though, is not so much a loosening of the standards in theory, but in practice, a greater ability for companies to demonstrate that they meet the standard. So, for example, you might say that it would be easier perhaps for merging parties to demonstrate current economic distress and an inability to recover, given the sudden and immediate shutdown of so many industries. And they might be able to demonstrate that more easily than historically looking at some sort of a pattern of decline. However, I think you still need to assume that the agencies are going to take a rigorous look and scrutinize those types of claims, even during the period of COVID. Agencies may also be faced with the fact that there are potentially fewer viable buyers in affected agencies for distressed companies and distressed assets. Nevertheless, the seller is going to have to do a good faith search to show that that's true, but the agencies may be more willing to accept a complete lack of available alternate buyers in those kinds of situations. I thought that Commissioner Oliveira's paper was very, very interesting. I don't think we know yet that the standard won't be flexible enough in the US to accommodate a situation like COVID. These are sudden and palpable, demonstrable shocks that have affected entire industries, as well as individual companies. Yeah. And so it certainly is possible that one way that the agencies will adapt is, again, not to focus so much on proving that the company has been failing over time, or needing such stringent tests to show that it has failed. I think that a lot of that is going to be much more self-evident in a situation like COVID than it would be in normal times. But the agencies can then focus more on the likelihood of recovery, which again may be slim because we don't know how long this is going to last. and also the availability of viable alternative purchasers.
Well, yeah, I think this last one may be the most difficult one to prove, right? Because in that situation, I mean, it's so unpredictable that companies may, of course, be reluctant also to put offers in failing firms, right? So, I agree with you. So, Johanna, what's your view on this?
Yeah, thank you. I essentially agree with Rachel, and it's a very, very similar situation in Europe. Margrethe Vestager, the EU commissioner, has explicitly said that the requirements for the failing firm defense will not be alleviated due to the current economic crisis, and most national competition authorities have stated similar things. Nevertheless, I also think that while arguing the failing firm defense will remain an exception, it may be easier in such a crisis situation to argue that, for one, a firm is going to fail and the market is deteriorating anyways. We do expect to see more cases. How many of those will be successful? That's really an interesting question. I think one thing to keep in mind is the failing firm defense in essence is an answer to an individual crisis of a company and not the response to an overall economic crisis. It's not quite fair, I would say, to apply the failing firm defense to alleviate a general economic crisis, but it can be a tool. And to get back to the cases you mentioned before, the Aegean Olympic case was actually, to my knowledge, the first one that actually took into account a more general crisis for the assessment of, for the counterfactual, in fact, for the assessment whether there was a prospect that the failing firm, the failing airline could still be on the market, or whether that would actually be leaving and the market share would, in this case, that was an easy duopoly monopoly case, whether the market share of the leaving airline would accrue to the remaining one. The commission decided on that case for the first time in 2011. So note, well, 3 years after the initial financial crisis, but at that time decided no, the requirements of the failing firm defense are not met, which is interesting because the crisis was there and the overall economic impact was there. Nevertheless, they tried again, and 2 years later, in 2013, the commission made a 180 degrees turn and said, well, now the situation is entirely different. The factual circumstances have changed. We'll see whether they simply sort of learned their lesson. We don't know. But then they unconditionally cleared the transaction. That's interesting because in 2011, it became clear afterwards the counterfactual issued by the commission was simply wrong. They had expected that the market would go up, that would develop positively, and it went in the opposite direction. So that's really the first and true crisis case that we've seen. The UK CMA has taken an interesting path in the Amazon Deliveroo case that was actually started in 2019, so well before the crisis. Amazon Deliveroo is a company that's still a loss-making business, as you probably know. So they rely on funding, and one of the potential funders was Amazon, who was supposed to obtain a 16% share in exchange for funding of, I think, a little more than 500 million euros. That was notified to the CMA, and the CMA by the end of 2019 found that there was a realistic prospect that this transaction could harm competition. It could reduce competition on the online convenience delivery markets in the UK. It went into phase 2, and then came COVID. And in April 2020, the CMA decided, well, balancing of probabilities of what's going to happen, we do see a substantial lessening of competition, which is the test in the UK. But given the urgency of the funding for Deliveroo, they nevertheless said, yes, we can conditionally clear the transaction and open in a consultation period afterwards. So they allow the funding, due to the crisis, based on something that's similar to the failing firm theory, and then saying, but we'll keep an eye on it. We'll be looking at it for longer. And now in early August, interestingly, the CMA found the market has changed dramatically, and the restaurant food delivery market has recovered much more sharply than everyone would expect it. So again, the counterfactual wasn't quite as easy and as correct as you would have hoped. So Deliveroo was no longer a failing firm. Secondly, and that's even more interesting, I think, the CMA said, well, but the market conditions have changed in such a way that the funding and the 16% acquisition of shares would not harm competition, because the level of investment was too low to significantly deteriorate competition and the activities of Deliveroo. That would be different if they acquired control, but so far, now we have an unconditional clearance following first a sign of we're going to COVID, then COVID-19 coming in saying, well, conditional clearance, and now here we are. I think this is quite a pragmatic way to deal with it, but I wonder how many cases you have where you can do that. I mean, in this case, it was about funding and a smaller share. Otherwise, I think you're running into the problem of how do you unscramble the eggs once you've conditionally cleared something, they've merged. That should be difficult.
Yeah, no, I hear you, and I fully agree. I think this leads me to the next question, actually, which is, on the counterfactual issue. We've discussed this briefly before, and I think the counterfactual is actually. Well, I always had a problem with that one, and it relates to the third leg, or the third leg of the three-prong test, which is, well, you have to prove a less burdensome alternative to the market. And then, well, one, it's a diabolic evidence, right? Or a diabolic proof, because you have to prove something that you have. I mean, you have to prove a non-fact, right? That's one thing. And the second is, it may give the authority, it may be too far-fetching for a competition authority as well, because it may allow the competition authority also to decide what would be the optimal market structure, right? So you have a bidder, and well, he wants to buy. You need to prove the counterfactual. He says, and then, well, prove me there's no less burdensome alternative here, and then I have to sell maybe to somebody who's offering less money here, but just because the authorities think this would be the optimal market structure. So, I mean, what's your views on this? I mean, I said already, I always had a problem with that one, but I wanted to hear from you both. What's your views, and how this has been dealt with in the US and in Europe? Please. Let's start with Rachel again. Oh, Johanna, well, let's do it the other way around, because it's always you. So let me start with Johanna then.
I'm fine either way, but I'm happy to start, of course. I agree that this is indeed quite a problematic criterion. Nevertheless, based on the cases we've seen, there have been a number of criteria defined in the decision practice from the Commission, as well as from the German Federal Cartel Office, which gives a certain hint. So the Commission in one of the cases said if it is highly unlikely that an alternative purchaser could be found, that would be sufficient. So they don't want you to prove there is none. But they rely on a certain probability. So you would have to show some of the market structure, who are the players in the market, why would potentially a financial investor not be suitable, etc. Also, an acquirer interested only in some parts, smaller parts of the failing firm would not be sufficient. The timing of the transaction has to be taken into account. You have to see up until when do you need the transaction to take place to save the assets in the market. So if an alternative would take too long, it's not a viable alternative. Also, insufficient expertise of a potential buyer wouldn't be sufficient. the German Federal Cartel Office mentioned that a credible long-term plan how to continue the target's business would be required for a suitable purchaser, which is quite a burden for a potential purchaser to be showing. They were also looking at issues like management buyouts where financing wasn't sufficient. So there is some possibility. And while it's not a clear picture yet, I think from the practical perspective, what we would need to do is to start search for an alternative purchaser in such a scenario as soon as possible and ensure that any type of bidding process is open. Don't target it too much at your preferred bidder, obviously. And then, of course, prepare extensive documentation. Show that you've dealt with the issue. Show that you've talked to potential alternative bidders or acquirers, and then explain why they're not suitable. In the end, it's an open issue, but I think there are a couple of criteria that may help.
Wonderful, thank you. Rachel, please.
I think it's interesting in the U.S. And to see how the test might actually be applied under COVID circumstances. I think much like in Europe, the case law does suggest that there's some flexibility and gives some guidelines for how you might successfully meet this part of the test. And the focus really is not so much eliminating all other possibilities as it is showing that you've made the reasonable effort to try to find that alternative bidder or alternative buyer. Again, when you're dealing with something at a standard that's like reasonable, I'm sure there can be debates between the parties and agencies about what reasonable is. And I think there's also a unique situation in that the assets, the value of the assets may continue to deteriorate. And the economic situation may continue to deteriorate in industries that are going to make this a very fluid kind of a determination. But I think it still does make sense to require some sort of a look and an effort and a reasonable process. If for no other reason, it also buttresses other elements of the defense. If a distressed company is looking to sell its business because it can't turn the company into a profitable concern, and the only interest that it gets is from a competitor, it does suggest to a degree that the market agrees that the company is failing, that it really is not in a situation to revive itself. And in terms of the overreach of the agencies and whether or not this is getting into kind of micromanaging the shape of markets, you know, in the United States, the failing firm defense is a last resort, really. Right. And so I would suggest that the parties are already in a situation where they're in a relatively concentrated market horizontally. And in that situation, you know, under the US theory, the best outcome from an economic perspective is to try to find a buyer that is going to keep the competitor relevant in some sense. And that is essentially what the agencies are trying to do. They're trying to show that that possibility really just doesn't exist as a practical matter. Otherwise, what you're looking at is the loss of competition, either through the merger or through some sort of attrition or liquidation.
I see. Well, that's interesting. And it also leads me to one of the questions that we received from the audience, actually, which is about remedies. You know, when we're looking at the situation that you just described, I mean, how do you think the authorities should deal with remedies in the context of a failing firm defense or a failing firm situation? The thing is, you know, should we apply the same standards? Are we focusing on structural, you know, remedies as you know we do in normal circumstances, or should we be looking more, you know, closely to behavior remedies? Do we need to have an upfront buyer? You know, imagine the situation where we are, you know, in a very distressed situation. The company is failing. We need to, you know, allow funding, and then you extend all the process by imposing an upfront buyer on a certain assets, right? So how would the clock work on a merger that where remedies are required? What do you think? Let's start again with Rachel then.
I think that because again in the U.S. this really is a defense of last resort. If there are actually remedies available that would ultimately blunt any anti-competitive effects of the merger, those would tend to be looked at and applied prior to the invocation of the defense. I think that those types of things would play out in the ordinary course. And typically, I think where you see the invocation of the defense, again, is in a very horizontally concentrated market situation where you've got a lot of overlap between the buyer and the seller. And in those situations, typically in the United States, you would be looking at structural remedies. So this really would have to be a situation where that kind of structural remedy just isn't available. And again, that also kind of ties into the different prongs of the failing firm defense. It really is to show that there is no other structural remedy available. There is no other buyer. There is no way to split up the company and still keep it a going concern in the market. As to timing, again, I think it will be interesting if we actually see a case in COVID era, but there are accommodations that the agencies can make within their existing timing structure to provide an expedited review. They can commit to doing an initial review within the 30 days provided by the statute, including an analysis at that point, or at least a preliminary analysis of the likelihood of the applicability of the failing firm defense. And the merging parties themselves can facilitate that review by marshaling their evidence, by doing their shop, and bringing the evidence supporting the defense to the agencies very, very early in the process, or even pre-notification.
Wonderful. All right. Johanna, please.
Yeah, I fully agree with Rachel. The failing firm defense usually comes into play in very concentrated markets, and also the markets concerned very often they're not very much suitable for structural remedies, and usually that would have been discussed in the course of the analysis of the transaction beforehand. So I agree, and I know there's still the general reluctance for behavioral remedies, but I think these cases may well be suitable for that, and they could also sort of sort out the timing issue, because that's usually done much quicker than the structural remedies. Very often in these markets, you have issues of access to services, access to products, and it can also could also be retaining distribution systems, retaining products. As a very hypothetical and a very unlikely example, if you imagine Apple mobile phone business acquiring Samsung mobile phone business based on the failing firm issue, that would for sure be an issue with regard to substantial lessening of competition for the mobile phone markets. But nevertheless, a behavioral remedy saying you have to retain the Samsung hardware would retain the upstream and downstream markets for products relating to the mobile phones, services relating to those phones, a lot easier to be done than any sort of structural remedy in that context. So I agree. We haven't seen many structural remedies in these cases. It's discussed beforehand, and it's either solved or not solved entirely.
Indeed, yeah, and I agree with you. I think behavior remedies in that sense would be, quicker. I mean, I'm not saying they are, always suitable, but we should definitely have a closer look at them, and in particular because it allows you also to follow up on the counterfactual, right? So you follow, the authorities will also have the opportunity to follow up on how the market develops from then on, right? Well, I think we're sort of running out of time here. I'll just allow you very briefly, if you can, to sum up or summarize something that you want to say to the audience, because I think we only have about 5 minutes left. But so please, Johanna, you want to start?
Sure. Well, thank you. I think it's interesting to hear about differences and similarities in the US. And my feeling is that there's more similarities than differences. And the main similarities being that the failing firm defense, while its basis is a little different across the ocean, it is a last resort, and it will be used scarcely. And I don't see the crisis, the current crisis or any other crisis to be changing that a lot. It will change the assessment of the counterfactuals from the European perspective. And we do hope to see a little more pragmatism from the national and European Commission, national authorities in the European Commission to apply these assessments. But I'm not expecting any type of revolution. It's ideological orthodoxy on the competition authorities side to a certain extent. Pragmatism is still something that's has to be acquired in a certain way. So yeah, I'm reluctant to see a revolution, but I think we'll see more cases in the coming months.
Very good. Well, thank you very much, Johanna. Rachel, please.
Thank you very much. I substantially agree with Johanna and everything that she said. I think in the US, the regulators are going to apply ordinary antitrust principles for the most part, even in these unprecedented times. And that will mean that merging parties can't necessarily count on any sort of a relaxed standard during the pandemic. But ultimately, the failing firm defense is still there. It's still viable and has been even in normal times. And possibly will have a greater chance to succeed simply because it may be easier for firms to convince the agencies of the having met the different prongs of the test, but not because the test itself is somehow going to be changed or lessened or made less stringent.
Very good. Well, thank you very much, you both, for this, great panel and this great opportunity to hear from both sides of the Atlantic. I think we Brazilians have, quite a lot to learn from the experience abroad. It's interesting to hear about, you guys thinking about a little bit more pragmatism from the authorities, because, last week, actually, we had a seminar about failing firm. And I heard one of the panelists say, look, well, competition authorities are conservative and they should be. I think this is the time possibly where they shouldn't. I mean, just be a bit more pragmatic in terms of what's going on, and a bit more aggressive, let's say, in looking at this new situations. Well, but again, thanks so much, Leonor. I guess the floor is yours again.
No, thank you very much, Paola. Thank you very much, Johanna. Thank you very much, Rachel. It was a big pleasure to have you with us. And next time, we hope to have you here in Brazil. So after COVID passes, we would like to have you here. So thank you very much. Have a wonderful day and have a wonderful afternoon and weekend.
Thank you.
Thank you all.
Take care.
Bye.
Bye.
Bye-bye.